Hey, everybody. Good afternoon. Good morning. Welcome in. Thanks for joining us. We're going to give just a couple of more minutes for folks to roll in here, but we appreciate you joining us on this busy January Thursday. We know there's a lot happening, and we're hoping in the next 30 minutes, Roman and I can give you all some great tools that you can walk away from the session and be more prepared for the upcoming H-1B cap season and all the curveballs that we might get thrown at us between now and the registration period. Um, Roman, with that, do you want to start off real quick with quick intros on yourself and LaborLess for those who don't know you, and then I'll do the same for Lawfully, and we'll jump right in.
Yeah, absolutely. Thanks, Finn, and hi everybody. Thank you for everyone showing up, and I see some familiar faces here, some new folks. So my name is Roman Zolchenko. I'm based in New York City, and also upstate New York. Do I travel between the two? I'm a former immigration attorney, so I worked at a firm and handled high volume H-1B cases as the majority of my work. And this was over a decade ago. Time really flies, and I even at that time felt that my support for clients with their LCAs and public access files was very manual, very paper based, et cetera. And I always felt that there could be a tool for it, and really nothing in the market was fixing that. So I eventually launched Laborless, which automates H-1B compliance. So we enable law firms and companies to post electronic LCA notices, automatically create, manage, and store electronic public access files, and sort of we're trying to wrap that entire PAF process or LCA and PAF process into software. We're also currently working on a perm notice of filing feature, which is very similar. That's maybe a topic for another webinar, but we're constantly thinking about how can we use technology and automation to support compliance within the immigration process.
Awesome. Well, Roman's going to do a demo of Laborless at about the 15-minute mark here, and I'm just going to kick things off with a demo of some of the tools we have at Lawfully. So for those of you who don't know me, my name is Finn Reynolds. I'm head of insights and strategy at Lawfully. Previously, I've worked at several of the large immigration law firms, BAL, Envoy/CIP, WR Immigration, and before that, I spent my time in DC, in and around government. And I've always had a real fascination with government immigration processing data. And that's exactly what we do at Lawfully. Lawfully is an immigration data and case tracking company. We started as a mobile app back in 2019. We've helped more than 3 million people track more than 6 million cases through USCIS in our app, providing more transparency, more benchmarks on processing times, approval rates, RFE rates, things like that. And last year, we launched our first B2B product, Lawfully Pro, which levels up case tracking for organizations. So law firms, global mobility teams, nonprofits, anyone who's tracking, dozens, hundreds, or thousands of immigration cases that are pending with USCIS. And then a couple of months ago, we launched a new offering called Lawfully Intelligence, where we take all of the data that we're tracking from those cases, and we're able to provide real-time USCIS case processing trends on approval rates, RFE rates, and processing times for H-1Bs, for L-1s, O-1s, EB-200Ws, EB-1As, and about 17 or 18 other case types as well. So all of that, I'll plug a little bit more at the end. But really what I'm here to show you today is a free tool that we created that anyone can use. You don't have to be our customer. You don't have to be a law firm. You could be an in-house global mobility manager, or just an individual who's interested in understanding how the new weighted lottery system works. So I'm going to go ahead and share my screen and just walk through that tool a little bit, and then I'll drop that. Actually, let me drop the link in the chat first.
And,
You
and
all,
hey, Finn, as you're doing that, I added a comment in the chat. For folks, if you have questions as we go, we're going to have a Q&A in the end, but put your questions in the chat. Sometimes I feel like I have a question, and if I wait for the Q&A, I forget it by the time the Q&A comes along. So put your questions in the chat as they come up, just so they're fresh in your mind, and then we will get to them once we're done with our short presentation.
awesome. Thank you for that housekeeping reminder, Roman. All right, I just dropped the link in the chat to Lawfully's H-1B weighted lottery simulator. So I've been the weighted lottery has been a little bit of an obsession of mine since we first heard about it in the summer. when the OIRA when the rule was being reviewed in OIRA. And so I dug into the proposed rule and eventually the final rule in more depth, and talked with a lot of former USCIS folks about how this is actually going to work. And I know that over the holidays, when the final rule was published, and given the fact that, back then we were 60 days away, now we're 40 days away from the H-1B registration period for the lottery, there's a lot of questions about how this new weighted lottery system is going to work because it's super, super ambiguous, quite frankly. It's an odd system. It's the one that USCIS has decided to go with. I know that there are legal challenges that are being prepared to be mounted by several organizations before the lottery or before the registration period comes up, but most likely this is going to be the system that we're all using for the H-1B lottery this year. And we wanted to create this tool, the H-1B lottery simulator, to help organizations and law firms help their clients really understand how this new system is going to be different from the randomized system of the past for their individual organizations. So it's fairly simple to use. All you need to do is plug in the number of registrations if you're a company that you expect to submit in this year's lottery. Uh, just as an example to start, in the past few years, the average breakdown of registrations by prevailing wage level, which didn't used to matter, right? Because under a random lottery, the prevailing wage level of the registration doesn't matter at all. But in the past, it used to be a breakdown that looked something like this. Um, it was about 42% level one registrations, 42% level two, 10% level three, and 6% level four. So not that like an average company had that breakdown, but that was the average overall. So it's sort of a good benchmark. Under last year's randomized system, there were about 340,000 unique registrations in total that were submitted to USCIS. So under the random system, most companies, if they filed or if they registered 100 H-1Bs, were having about 30 to 35 selected. There were about between a 30 and 35% selection rate. Under the random lottery, that wouldn't change, excuse me, under the weighted lottery, that wouldn't change that much if you were an organization and you were submitting, again, 42 level one registrations, 42 level two, et cetera, et cetera. You have a slight dip, and that slight dip comes from the fact that level one and level two are getting selected at a lower rate. So as opposed to last year where a level one registration had about a 30 to 35% chance of getting selected, this year, if the number of registrations stays the same, that gets cut in half to about 18, 19%. The key here, and if you read the rule from USCIS that they put out, the numbers they were using are pretty old. But the thing that we wanted to point out in this simulator is that number of registrations substantially impacts what the overall selection odds will be, right? So if this year there's a 15% drop in the number of registrations, right? There's 290,000 instead of 340,000, that's automatically going to increase the selection odds for any organization. Same thing if there's a 30% drop, right? It's going to continue to go up. The other thing that can increase selection odds, as you all well know, is if you could find a way as an organization to submit more level three and level four registrations as opposed to level two and level one. So like, let's do that real quick, right? If we're going to submit, let's use 100 because it's a nice clean number. If you're going to submit 20 level one wages and 20 level two wages, and then 30 level three and 30 level four, right? A 55% selection rate. If there's a 30% drop, we can go back to the baseline, it's still 42% selection rate if it's the same number of registrations as last year. So the more level three and level four that you register, the higher your overall selection odds will be as an organization. Last thing I want to point out here, again, as the overall number of registrations drops, which it's highly likely that's highly likely to happen because the looming cloud of the $100,000 H-1B visa fee takes out a lot of potential registrations that last year were part of the pool and this year just won't be because organizations won't submit them. The individual selection odds for level three and level four go up substantially, right? So a 30% drop this year could mean that any level three registration that you submit into the lottery has a 60% chance of selection, 70% for level four. that's double what it was last year and really has been over the last couple of years, where the average has been anywhere between like a 20 and 35% selection rate. So that creates a real window for a lot of individual applicants at any organization. Um, so that's the tool. We make it again fairly straightforward to use. If you have any questions, I'm happy to give you a walkthrough. And then the other thing I've been doing for several global mobility teams, and for law firms on behalf of their clients, is putting together just like a slide deck version of the simulation, so that you can share that with internal stakeholders and help them understand sort of what's at stake in this new lottery, and the fact that there really could be a window if you're an individual organization who has a lot of level 3 and level 4 registrations, that this is the year you might really want to consider submitting them, because the selection odds are going to go up substantially for them, regardless of if there is a drop in registrations, which again I think is highly likely.
And if I can chime in for a quick question for you, and I think about this from the perspective of laborless too. Okay, so this is great. Folks are seeing how it works and the information it provides. How can a law firm use lawfully intelligence, or specifically this tool, versus a company? Because, like for laborless, for example, the relationship is different. So would the idea be that if a law firm is using this, they can then run the simulation for all of their clients? Does every client have to pay in? Like, what does that look like for them?
It's a great question. So right now, if you're a lawfully intelligent subscriber, I'll prepare these reports for, if you're a law firm, for as many of your clients as you want for free, or as part of your subscription, I should say, in the lead up to the app. And if you're a global mobility team right now, you can email me. I'll drop my email in the chat after I hand it off to Roman here in a minute. If I have the capacity, I'll do these for other folks as well. Because again, it's the conversations I've been having with global mobility teams who traditionally submit hundreds or thousands of registrations in the lottery, is that internally, this new system in combination with the $100,000 fee is creating a lot of confusion around, like, do we want to spend the money to enter these 40 people that, are maybe on the edge into the H-1B lottery or not? And so that's something that we're trying to help give global mobility leaders and law firms the clear information and data to show, hey, there are advantages this year under this new system and this new landscape to submitting more of these folks, and there might be disadvantages, higher risks rather, to submitting folks with a lower prevailing wage level. Um, and Roman, I can sort of hand it off to you here next, because this is the last bit that I wanted to include. So last week, we did a session at Lawfully with a former division chief named April Padilla, who was a division chief at USCIS in one of the fraud units. And we talked through some of the incentives that are created by this new system for global mobility teams to increase their selection odds, and what the risks might be from a compliance standpoint, that USCIS will be looking into in the summer and fall. And April shared that she highly expects, as a result of the this new system being implemented, that USCIS will plan on doing more site visits in the summer and the fall, just because there are a lot of companies that are going to potentially reclassify applicants' SOC codes. Maybe last year they submitted them as a software developer, and this year they're going to look at a different software code, or excuse me, a different SOC code, because they can pay that individual the same salary they're already paying them, but their prevailing wage level goes from 2 to 3, and therefore their odds of selection could increase by 20%, right? That's the calculus that I know some companies are discussing right now. The other is remote work, right? Like, remote work sounds a lot more appealing if, for example, you can have an individual work at their house in Walnut Creek, as opposed to in the office in San Francisco, where if they're a software developer, the real salary for a higher prevailing wage level is tens, hundreds of thousands of dollars more, across the board. So a lot of companies are considering these options in the lead up to the lottery. USCIS knows that, and they're going to be looking for instances, inconsistencies in how SOC codes are applied, and how and when salaries are paid. So that's, I think, hopefully a perfect segue to my friend Roman to talk about how to stay compliant when it comes to the H-1B cases that are selected in the lottery, that are filed and are hopefully approved.
It's so funny because when you think about remote work, companies often say, well, where can we place somebody who's, at a lower cost location? But now it's, this sort of weighted lottery system has created the opposite approach where you think, well, I hope they will live in a place that has really high prevailing wages so that they can work from home at least part of the time. Yeah, thanks, Finn, for that. Really, really interesting. I mean, I learned something too, certainly. Okay, so thank you for that. Okay, so in this process right now, the company has gone through this kind of analysis, and maybe they decided, all right, let's file for these people. We're going to do it a certain way, and we're going to participate in the H-1B lottery. And so, let's say the registration period happens, some folks get selected, and of course, now it's time to file for these cases. I think when the registration system first sort of went live, a lot of companies just filed LCAs anyway for everyone who is registered, kind of as a precautionary method. But as far as I've seen over the past couple of years, that's not really the case. At this point, people are waiting to see who gets selected, and once they get selected, they move forward with the cases. All right. So now that has happened. As usual, the law firm typically has to start off the process or kicks it off with the LCA. So you grab the information about the role, about the individual, the salary that the company is going to pay, and you start to go through the process of finding the right prevailing wage, finding the right SOC code, etc. And you have to comply with the LCA posting process. So traditionally, the way law firms do this is they create an LCA posting, document, like a one-page posting notice. They'll send it to the client, and they'll ask with an email to. And by the way, if you are like this, please in the chat, like give me a thumbs up or a yes if you're willing to be open about it, because honestly, unless you're using a tool like Laborless, you're probably doing this. You're sending emails to the client saying, please, print this out, post this in two conspicuous locations. Please let us know or confirm with us once you have done the posting so that we can actually go into Flag and and submit it. And the challenge with that, and this was my challenge. I mean, this is literally why I left being an attorney and launched Laborless eventually, is the clients don't do it right away. And so you're chasing them. Did you post it? Did you post it? We have to move forward with filing, submitting the LCA. Obviously, after that, even once that's done, you have to send them the public access file. So you have an email with certain documents and instructions on how to create it, and maybe instructions on what to do with in the event of a site visit, etc. So I see that most people are going to be shy, but I know that y'all are probably doing this because it's just the standard way of doing it. So the idea behind Laborless is that it gives you. So I'll share my screen very quickly. And I'm not going to go through a full demo, but the idea behind Laborless is that it gives you a tool. So as a law firm, you can post LCA notices for your client. Okay. And if you're an employer, you can move to electronic posting, whether or not you're handling the H-1B internally or you're handling the H-1B through outside counsel. So the first thing that a company does is a company adds their petitioner. So if you're a law firm, you'll have multiple petitioners. These are all of your clients. If you are the employer, you will have either one petitioner, or if you have multiple legal entities, you'll have several, a petitioner for each legal entity. And so the idea is when you create a petitioner within Laborless generates a unique URL for that company. So let's say always use Acme Software Solutions Inc. And so like I'll click this URL button. As you see, it opens up a new tab. And this URL here is the unique URL for, in this case, Acme Software Solutions Inc. And it is this company's LCA posting bulletin, online LCA posting bulletin. And the idea is that you take this link, and you, as a law firm, you'll share it with the client, or as a company, you'll grab it from Laborless, and then you have to communicate it with your employees in a way that you typically communicate job opportunities, or legal or immigration notices or things like that. So oftentimes adding a link somewhere on your intranet that works. A lot of companies add it on their external careers page, so where they typically post about job opportunities. If it's a startup, I've seen them added to their Slack or their Microsoft Teams or something like that. Clients also print out a piece of paper. So let's say you're fully in office, and they'll post the piece of paper in their office with this link. We have a QR code function too, so you can generate a QR code that goes to the same link, and they post it on their in their office, and then they leave that there. So rather than when you typically ask a client to print and post an LCA notice, take it down every time, and so imagine you're doing it dozens, hundreds of times per year. Here you do this once, you leave this posting up there, and that posting is effectively redirecting anybody who's interested to their Laborless bulletin to see what LCAs are currently posted. And the idea, of course, is if you're a law firm, you tell your clients, look, you know how we always send you this email back and over and over and ask you to print and post and all the back and forth. Here's a link. You figure out how you want to communicate that, whether it's again on their intranet, on their public facing website, in office. Some companies actually update their employee handbook. We know of law firms that do that with their small companies, and add the link in there. And so you tell the client, once you do this, you never have to hear from us again about LCA postings, because with Laborless, every time there's a new H-1B, either initiated or new transfer or an amendment, whatever it might be, the law firm is the one that goes into Laborless and does the posting, and the company never has to deal with it again. So the benefits are, number one, the company is just happy because no client ever was excited to get the email and have to deal with the LCA piece. And number two, the law firm has more control over the time, and has more transparency into what is actually being posted. Is it being posted at all? How long is it being posted for? Etc. So law firm posts, or if you're a company, we have a lot of companies that use Laborless internally because they have a team internally that handles H-1Bs. So same thing, it saves them the time that they would ultimately spend, or traditionally spend, printing and posting. If they have multiple offices or regions, they don't have to send it to those folks. Now, in terms of remote workers, you also no longer have to send a notice to your remote or hybrid worker to print and post on their refrigerator or in their bathroom. It's crazy. It doesn't make sense. We all do it because the regs haven't been updated. And so it's the thing that we know is quote unquote compliant. But whenever you ask someone to do it, it doesn't make sense. Plus, how do you confirm that they've done it? Maybe you have to ask them to take a picture. And send it back to HR, and then HR has to confirm and send that back to the law firm. It's just a chain of emails that, especially during cap season, when things are happening quickly, it is just a pain. And so, again, with Laborless, you get rid of all that. In terms of the public access file, again, I'm not going through the whole demo. I'm more than happy to I have a demo video on our website, or I can set something up with anybody here. But basically, when you post the LCA notice, Laborless pulls in some petitioner documents, so benefits documents, etc., and combines them with the LCA posting, the prevailing wage info that the user uploads, actual wage memorandum that the user uploads. So all these documents that you already have, they're already part of your process. But instead of, again, the back and forth with the client, everything goes into Laborless, and a public access file is actually compiled and generated immediately upon posting the LCA, which is more compliant because PAFs are supposed to be created within 24 hours of posting the LCA notice. And I can say that as an attorney, when I was practicing, maybe I didn't always get to it within 24 hours. Now, was that okay? Sure, because, DOL or whoever wasn't banging on the door asking for a PAF when an LCA was posted. But in the event of a site visit, in the event of an audit, in the event of any kind of additional scrutiny, I mean, I would want to make sure that all of my I's are dotted and all my T's are crossed. And the best way to do that, in my view, is with technology. So it allows you to post the LCA notice immediately. It has a function that takes the LCA posting down after a certain number of days. Obviously, you would want 10 or more days. Maybe you could disagree if it's calendar or business days. You choose, right? The user chooses how many calendar or how many days the LCA is posted for. It's taken down automatically. The path reflects the dates that it was posted for, and it's stored there. Now, in terms of the public access file, you theoretically now have everything in one place. The LCA postings were here, but then also the corresponding paths are here. And in the event of an audit or somebody coming in off the street, I mean, I've talked to clients that have their paths somewhere they don't know, right? Especially when people come and go, if in an HR department or an internal mobility department, they don't always know where these things are. So I'm going to go to the dashboard and let's just look at I'll go to this completed tab. So these are LCA postings that have been posted and taken down. So, the job title here, these are the various work locations. This is the petitioner. So I'm using a fake company, Acme Software Solutions, and it was posted on this date and taken down. So let's look at the software manager. If I click into it, you get some details about this position. You have here separate files that are uploaded into Laborless that make up the path. And then, of course, Laborless automatically creates this path. So when I click on it, it opens up as a PDF. This is an auto-generated form that has all the information you need, and importantly, it has the work locations that it was posted for, and the date that it was taken down. This one is actually it's been reposted. So this is a situation where somebody has moved within the same MSA. I mean, you can ignore the addresses here, but let's pretend they're within the same MSA, and you're just reposting an LCA notice. You can do that through Laborless as many times as you need. The LCA notice just pops back onto that LCA bulletin that I showed you earlier, and when the days are up, it comes back down, and and that's updated in the path as well. And if you scroll down, you'll see whatever's in the path. So here we have the LCA posting. Let's pretend this is an actual wage statement. Prevailing wage information, etc. A couple of small things we have here. You can send an LCA acknowledgement to the beneficiary. So that's another part of the process where you have to send them the certified LCA. You can do that here, and Laborless tracks who it was sent to, right? When it was sent, and you can even look at the file that was sent to them. So in this case, it was their LCA, et cetera. And so ultimately, the idea is with Laborless that you, as a law firm, can provide this as a service. You go to your clients, you tell them in preparation for H-1B cap season, we're going to take this LCA compliance process off of your shoulders. The little bit of work they have to do up front is just take that URL and again communicate it with their quote unquote affected workers in a way that you deem legally sufficient with them, depending on how they typically coordinate with their employees about again job openings, legal notices, immigration stuff, etc. And then once you do that, the client or the employer no longer has to deal with this. Just a couple of final thoughts for companies that have multiple legal immigration providers. Some really large companies have that. We found that when they own the Laborless relationship, we don't care who uses it. So we have instances where the client, the corporate, uses Laborless. They have an account with us, right? They pay for the license, but then their outside counsel actually log in to use it. So that's something that works where a company says, look, we want to own this relationship with the software. We want to centralize all of our LCA data because maybe we have multiple vendors, some for cap season, some for really difficult H-1Bs, whatever it might be. And so we'll own everything, and the outside counsel folks can be the ones in Laborless. The flip side of it is law firms that have corporate clients can do this for them and really find efficiency. But then also law firms that have a lot of startups who are not going to know anything about H-1Bs most likely, and they do one or two or three a year. But cumulatively, as a law firm, you might have 100 or more H-1Bs that you're supporting for the year. With Laborless, you can make sure that you don't have to worry about those employers not doing it correctly. You provide them with a link, they share it somewhere. Again, as a startup, they could put it in their employee handbook or on Slack or something, and then you deal with the LCA posting in the path, and you manage everything. And the last thing I'd say is law firms for the most part are paying for this. And so charging for this. And so it's totally fair and legitimate in my view to go to your client and say, we're going to provide you with this additional service. It's not an increase in fees, just because of an increase. It's it's a new administrative fee. It's a legal and a compliance fee, and it almost always more than covers the cost of Laborless. Laborless is not very expensive, and for a client to pay an extra 100 or $150 or whatever it might be per H-1B to not have to worry about the compliance piece anymore and not have to deal with it, in our experience, most clients are more than happy. So it actually becomes a revenue center for law firms that offer this to their clients. So hopefully that was helpful. Again, I didn't go through the whole product, just wanted to give a high level gist. And this is kind of what it looks like. But please reach out to. We'll end for Q&A right now, but please reach out to me for information, for pricing, for a demo, or if you have ideas. I always want to chat. So thanks.
Awesome. Hey, Roman, we got a couple questions in the chat too for you. So I can read those off if you're ready and we could just jump right
Yeah,
into the Q&A.
let's take a look. Well, let's see. The first question we had was for you, actually. Great tool. Are you assessing the impact of U.S. master's degrees in the lottery? Oh, you actually answered it.
I did. Yeah, I can say it
Great.
here for those who aren't looking at the chat too. So the model that we built the simulation off of is based entirely on public data. So it's a mix of the data that USCIS publishes, the most recent LCA data. Roman mentioned it before. Back in the day, there used to be hundreds of thousands of LCAs filed for H-1B cap because people would file them before the cap. Once they put in the online registration and as part of the lottery, 2 years ago that changed, and now it's pretty much one to one. Like this past year, there were about 120,000 unique selections in the H-1B lottery, and there was about 120,000 LCAs filed for new employment for CAP. So that's the underlying data that we use. And then we also use Bloomberg did a FOIA, and they got the most detailed public data on H-1B CAP ever, and they made it available to the public, but it only covers FY 2021 through FY 2024. Parsing out the masters selections and registrations from everyone else is a bit difficult. So we're working on a better model for that so that we can provide a reliable simulation.
Well, yeah, thank you for that, and thanks to Bloomberg for doing that. Um, okay, so a couple questions here. So Indu asks, does this work for consulting company third party work sites? So so the short answer is yes, with an asterisk. And I'm more than happy to talk about this at length. The challenge for anybody who doesn't work with third party work sites is that the petitioner, the H-1B petitioner, when they place an H-1B worker at a third-party worksite, the third-party worksite theoretically also has to post the LCA notice as a worksite. However, it's not their employee, and oftentimes they just refuse. Right. And so what happens is the company that's hiring the H-1B, especially consulting companies where their business model is we hire H-1Bs, we train them or they have certain skills, and then we place them at third party work sites. They have to decide, are we still going to place this person and run the risk of not being compliant? So with Laborless, here's what we've built for it. We have a third party worksite feature that creates a separate, if you will, sub URL. So imagine you're a law firm, your client is Microsoft, and Microsoft is, or that's not a good example because they mostly have in house. Your client is Acme Software Solutions. So you hire folks, including on H1B, and then place them at various companies to do short or long term projects. So you, Acme Software Solutions, are placing this person at a third party work site, and you have your own URL that has all of your H-1B workers, including internal folks and all of your folks that are going to third-party work sites. Well, Laborless allows you to create a sub URL that is a specific site only for the third party work site. The idea is the company can, or the law firm can send that URL to the third party work site and say, this is for you. This is a specific URL for you. It only shows LCAs that are posted on your work site. Please share them wherever, post them somewhere, etc. So some companies are okay with this, but again, the challenge with third-party work sites is that they're usually not cooperative, and they don't care if you're sending them a piece of paper to print or a URL. And in that case, what we see companies do is they accept the fact that they cannot control the third-party work site, and so if they don't want to use that third-party work site URL, what the main petitioner does is they add the LCA notice to their public facing careers page. So company.com/careers, with the idea being that their LCAs are just public. It's not that they're in their office only for affected workers to see. They are on their website available to anybody. And, the argument there is if the DOL comes in and audits you and says, look, this person's at a third party worksite, why is there no LCA posted there? You can show that you clearly sent them a URL, you gave them easy instructions, you asked them to post it. They refused, they denied that. And so you're still doing the best you can, which is by being as transparent as possible by placing the Laborless URL on your public facing company website, as the main petitioner, so that theoretically everyone can see it, including folks that work there. Is it perfect? No, of course not. And this is the big gray area and challenge with H-1Bs when it comes to third-party worksites. But my view is that, and again, the clients that use Laborless that have third-party worksite placements is that, excuse me, it's better than the current scenario. And, with these audits, sometimes you do the best you can and officers can be more understanding or whatnot. And so the argument is we're doing everything we possibly can. And that'll be better for them. So Indu, I'm happy to talk further. Again, it's a gray area that's always been the case, and unless things change in terms of regulatory language or requirements, I don't see the third party worksite piece becoming much easier. But that's what we do there. So Grace asks, how do LCA signatures needed by in-house teams work after the LCA is approved? If I understand your question correctly, is whether or not companies still need to sign the LCA notice or something like that. I mean, generally, I mean, I guess if I can answer it by sharing with you how Laborless works in that way, when you after the posting is done and on the flip side the LCA is certified by Department of Labor, the employer still does have to sign it, right? Because the PAF, well, first of all, you have to give a signed LCA to the employer, to the beneficiary. You have to include a signed LCA in the filing, and then of course a signed certified LCA should also be in the public access file. And so the idea there is that the company does provide the law firm, as they always did, with the signed certified LCA for them to file. The law firm just also takes the extra step of taking that signed certified LCA and uploading it into Laborless to add into the public access file so that the public access file is complete. And again, the law firm can also send that certified LCA to the beneficiary for their acknowledgement. So I don't know if that kind of answers your question, but yeah, the company still has to sign. Unfortunately, DOL doesn't accept electronic signatures yet. As far as I know, they accept scans of wet signatures, which is a step in the right direction. But as far as I know, they don't accept electronic signatures. But Laborless still enables you to sort of capture that and utilize it. So hope that answers your question. Any other questions for us? So you have a couple minutes. There's a great group here. Any other comments or thoughts? I mean, this is a really experienced group of folks that have done tons of H-1Bs. If anyone else has any feedback or they want to share, or anything like that, please drop it in the chat.
And maybe Roman, while we're waiting for folks to jump in the chat, you and I
Sure.
were DMing back and forth about this on LinkedIn yesterday, sort of a developing story. But there's reports coming out that USCIS, FDNS, the fraud detection unit, is planning widespread site visits in Texas, specifically in the Houston area.
Right.
And there's sort of an operation underway. And what I've been told is that the goal is for it to be similar to what they did, what FDNS did. Um, in Minneapolis over the summer. I don't know if everyone remembers that, but there was a sort of a big fraud investigation that they had a big press conference about where they uncovered different types of, I think it was like interview fraud. They're planning a full operation right now, specifically though for H-1Bs, individuals on F1 STEM OPT and OPT as well, but really H-1B companies that are hiring workers on H-1B. One, I know you dug into it a little bit more, so if you have any thoughts to add, let me know. But I think it sort of puts an exclamation point on how important uh, compliance is, especially going into the weighted lottery system this year, and how serious USCIS is taking in terms of this issue, in terms of actually putting resources towards it, and real planned out operations for site visits to companies that sponsor H-1Bs.
I mean, look, I'll say this: when Laborless was first launched, and I reached out to the lawyers that I built relationships with over the years, and I demoed it to them, you know, a non-zero amount of lawyers were like, "What the heck is this?" And I would never use this, or this isn't legal, or it's never going to work, or no one's going to adopt it. And to be fair, thankfully, I didn't listen to their advice and kept going. But like to look at where we are now in comparison to where we were, even in the first Trump administration, it's scary. And my view, I hate that this is the case. I am grateful that I'm not practicing anymore, only because of the immense amount of stress that everyone is experiencing. But I feel it secondarily because our clients are, stressed out, and I'm grateful that we have a tool that can, you know, give some form of solace or some support or some additional, insight, or however people want to feel about it. But I think whatever people do right now, advising on H-1B compliance, it's been a secondary thing. It's always gray. The public access files, no one cares. People are starting to care because the government is starting to care, and they've made it very obvious. So all I can say is, I hope no one here gets audited, and thank you, Marianne, for the kind words as well about Laborless in the chat. I just think folks, the attorneys here have to think more about how they can strategically advise clients. Again, the reason we did this webinar, number one, the data to determine who you should be filing for, and whether it makes sense to file, and how many, et cetera. And then number two, once you do decide that, have everything in your arsenal to make sure that you're as compliant and as possible. And so again, Finn, thank you for setting this up. I just think that what we both Lawfully and Laborless um, are sort of let's say niche tools, right? We're not the traditional case management platform. So obviously, there's a lot of room for folks to learn about us. But I do think that right now, more than ever, what we have happens to be very useful. And, hopefully this webinar was useful to folks here to think about, you know, what you can do going forward.
Yeah, absolutely. I share the sentiment, Roman. We will send out the recording to everyone who joined and anyone who maybe was only here for the second half, so you can watch the whole thing back as well. We'll have the video recording, and then the audio recording will go out on our respective podcast feeds, which you should subscribe to if you haven't. Mine's the Real Time Immigration Podcast on Spotify. Roman, what's your podcast and show called?
It's called the GMI Rocket Show. If anyone here wants to watch it, by the way, anyone could email me, I'll put it in the chat as well, Roman@laborless.io. I follow most of you, or I'm connected to most of you on LinkedIn. So please message me. I'm always on LinkedIn if you want to chat about Laborless or anything else. But the show is called the GMI Rocket Show, and I mostly interview immigration tech founders. Somehow I got up to episode 142 last week, and there's still more people. This industry is just booming right now with um, in entrepreneurship and with kind of people building cool stuff. So if it's of interest to you, on a bike ride or on a long drive, and you want to hear stories about entrepreneurs who built things in our industry, everything from INS Zoom founder Umesh to the AI companies that are just starting up today, and everyone in between, including Lawfully's founder June. Everyone's on there, so check it out. GMI Rocket Show.
Awesome. Well, thanks so much,
Cool.
Roman. Thank you everybody
Thank,
for taking the time
thanks
out of your day to
everyone.
do this, and we'll hope to see you again soon. Bye bye.